Welcome to Training for HOA Boards, brought to you by HOA-USA. The subject of this video is legal considerations. First of all, know the legal name of your association. There's quite a lot of similar names within each state. That can be such as the Riverview Association, spelled out as one word, or River Space View, or Riverview Section 1, or the Riverview Condominiums. So it's important that you understand the exact legal name of your association. You'll find that in the Articles of Incorporation. And be sure that your contracts, your meeting notices, your minutes, your insurance policies, any other governing documents that you may have reference this correct legal incorporated name. Next, the registered address of your association. Most of the times this information is out of date, and it references all the way back to the developer, who may be in a different city entirely, or the filing attorney. The consequence is that the board may not receive something called service of process in the event that there's a lawsuit or other important notices such as public hearings. Be sure to check online with the Secretary of State in the Corporations Division and look for the form, the instructions, and the fees. We're going to talk about the chain of governing documents. Part of this is law, part of this is governing documents. We're going to take the law portion first, beginning at the highest level, and that's federal laws. And so we're going to see that there are a number of federal laws that apply to associations, such things as the Fair Housing Act, the Americans with Disabilities Act, Title VIII of the Civil Rights Act, the Fair Debt Collections Practices Act, the Freedom to Display the American Flag, the Virginia Graham-Baker Pool and Spa Act, Over-the-Air Reception Devices Act. That's really satellites. Some people refer to that as OTARD. Now we also have state laws and legislation. And examples of that might be nonprofit corporations, specific laws dealing with condominiums versus planned unit developments, stormwater runoff, even things such as water management, sometimes called xeriscaping. And then at the lowest level, we have local government ordinances. And there you can rely on local government laws to control things such as abandoned vehicles, animal control, occupancy, noise, on-street parking, irrigation, trash cans, and snow removal. It's important for associations to know that they should not undertake enforcing laws that local, state, or federal government can institute. Now, on our chain of governing documents, let's talk about the Articles, the Declaration of Covenants, Conditions, and Restrictions. This is the CC&Rs. The plat, which is a recorded map or a survey of the property that shows property lines, common areas, easements, and rights-of-way. There is the Articles of Incorporation that formed the association. There are the association bylaws. And then you may have other rules and regulations or resolutions. Some of these things might include rules for the pool or renting the clubhouse. What about in condominiums? What kind of floor materials for sound and noise issues? Pets, exotic animals, there's parking, there's smoking, exterior paint colors in townhomes, landscaping, mailboxes, yard sales, document retention policies, budget resolutions, covenant enforcement policies. There's a wide range of rules and regulations and resolutions that the association board can undertake. Now, know your governing document provisions. On the left-hand side here, we see that there are several examples of covenant provisions. These are the covenants. In a minute, we'll see the bylaws. But in the covenants, let's take a look at it. It defines the membership classes, usually as Class A or Class B members. There is a declarant control period. That's while the developer still has control of the association. There are rights and responsibilities of both the association as well as the membership. The assessment and lien process is defined in the covenants, as well as architectural control. There's covenant restrictions, amendments, and then there are terms for how long the association can remain organized and what are the procedures for dissolution. As we take a look now at the bylaw provisions, making a distinction between the bylaws and the covenants, the bylaws cover such things as the annual meetings, board meetings, special meetings, the size and makeup of the board, what are the terms of the board, election policies, quorums, proxies, and amendments. As you may consider selecting an attorney, keep in mind that it is critical that you use an attorney with skills and expertise in HOA law. Some of the fields and the areas in which attorneys will be critical to the association include collections, liens, and foreclosure, covenant enforcement, advice regarding changes in the laws and best practices, drafting rules and regulations, making amendments to the governing documents, serving in litigation, or as general counsel to the association. I want to emphasize that it is critical to use an attorney or a law firm who has the experience in this very specific field of practice. Also, before you jump out and start amending your documents and so forth, it's important that the association get a sense of the neighborhood and whether or not these changes to the documents might be approved. If you don't think you have the necessary votes for approval, do not spend unnecessary funds going and having an attorney look at the issue for you. That covers our discussion on legal considerations. Coming up will be budgets and financial reports.